DP. Mr. Briggs is here today after failing to appear before this court on September 27th, 2017. Bond is currently set at $500. This is the second bench warrant. He reports no employment. Last payment made on this account was in August of 2017. That was a $500 bond forfeiture. The court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on October 4th, 2023 at 8:45 a.m. before this court.
Thank you. Mr. Briggs, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on October 4, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, I have no money. I have 4 kids at home that are waiting on me. I really don't. I want to make a payment plan that I can pay you, so I don't have to come back up here and go back to jail. You know, I don't have a car or nothing. I just want to get a affordable payment plan that I can pay for the child.
Well,
so I won't.
Okay. Well, you had a chance in the last 6 years to come up with some sort of a payment plan. You haven't done that. So the court's.
I'm sorry.
Go ahead.
I haven't had a way to get to Calhoun County. You know, I don't have a car.
Well, you don't have to get to Calhoun County to pay your support. You can pay it basically pay it into the state. So there's a lot of ways you can pay it. You don't have to get here.
How much were my payments? Are my payments that I'm supposed to pay?
I don't know. You'll have to look at your paperwork. I don't have that information right now. Well, what I'm going to do is, again, it is your second bench warrant, so it takes, of course, taking that into consideration. But as stated, you haven't paid in over 6 years, so I'm taking that into consideration. And the only payment you had was a bond forfeiture previously. So what I'm going to do, I'm, of course, going to continue the bond at $500. If you're able to post that, you'd be able to be released. Do you have any questions? No? Okay, thank you. You're free to go. It's 8:34 a.m. Have a good day.
DS. Ms. Branham is here today after failing to appear before this court on September 13th, 2023. Bond is currently set at $1,391. This is the third bench warrant. She reports that she is employed by Uber Eats. Last payment made on this account was in July of 2019. That was a $100 bond forfeiture. The court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on October 4th, 2023 at 8:45 a.m. before this court.
Ms. Branham, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on October 4, 2023 at 8:45 a.m. Are you able to post a bond, ma'am?
No, I started my Uber Eats job the day I got arrested. I didn't even have time to make a run. I was on a run to Uber Eats because I can't donate anymore. Well, I can now, but I wasn't able to donate. That's how I was going to pay my child support. But other than that, no, there's no way for me to post a bond until I start my job.
Okay. Well, the court does note it is your third bench warrant, and the court notes that you basically haven't paid in over 4 years. So the court's taking all that into consideration. What I'm going to do is set your bond in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
If I can't put it, well, I'm not going to be able to post that bond. Is there, how do I want to ask that? I'm sorry, I got hit in the head of my memory screwed. And now if I do it until October 4th, I mean, I don't know how that works.
What happens is the hearing's on October 4th. We'll take care of everything at that point. But if you don't post the bond, you won't be released until after that date.
Okay.
Okay?
Okay.
You're free to go. Have a good day. Court will note the appearance of Attorney Smith on behalf of plaintiff, Ms. McNiff on behalf of defendant. We have actually 2 matters that were previously scheduled and were renoticed for today's date. Plaintiff's motion for change of custody parenting time and plaintiff's motion for an in-camera interview of the children in this particular matter. I will let Ms. Smith know, we had let Ms. McNiff know we had a mix-up with the clerk's office. The clerk did not get Ms. McNiff's answer to me, so I have not had an opportunity to review that. For your edification, Ms. Smith, you don't have to file a motion for an in-camera interview. I interview every child that's over 5 or older. So,
Okay, thank you, Your Honor.
so you can proceed.
Yes, sir. Between the last custody order that was entered on June 11th, 2019, and now there has been a significant change in circumstances on both parties' side that would prompt a review of the current custody order by this court. The minor in question here is 12 years old. The parties share one minor child. Since the entry of the 2019 order, defendant father, who has sole care and custody currently of the child, has not been able to provide stable housing for the child. There's been a change of the custodial environment affecting the child, and modification of the current custody order would be in the child's best interest. The defendant has failed to provide stable living environment for the minor. He has been living with girlfriends since the 2019 custody order. He's lived with one girlfriend, and then once they broke up, he lived with another girlfriend. And then earlier this year informed that girlfriend that he was homeless. Defendant has not been able to secure his own housing or sleeping arrangements for the child. The child does sleep in the basement with no egress window. There was a CPS investigation, and when CPS came, a mattress had been moved to another room of the home for the child to sleep in, but that is not where he primarily sleeps. Defendant has not been actively involved in the child's education. The child at one point in time during last year's school year had 17 missing assignments. He had multiple tardies and absences, and that resulted in 2 failing grades. I do believe he was able to bring those grades up, but the point that he was failing classes and had 17 missing assignments under the care and custody of defendant father. Defendant has also threatened to physically harm the child. During one incident, he did slap the child across the face and kick him out of the house during the winter. The child did not have a coat on during that time, and he was also battling strep throat at the time. Defendant father did call plaintiff mother to come and pick the child up at that time. The defendant has periodically left the child with family members while he's gone out of town. The minor child has not seen defendant father many times over the summer. The minor child was living with the defendant's mother and his grandmother. He had no things of his own. All of his things were being sold off by the defendant father's girlfriend, who is presumed to also have struggling with a drug addiction and drug use. In the meantime, the mother has been able to have the same housing and job for the last 3 years. She is the one that the child looks to primarily for guidance. She is the one that the child opens up to and speaks to about how he's feeling. He looks to the plaintiff mother, for the necessities of life. There was one point in time when defendant father was not able to provide the child with school clothes, and plaintiff mother and her mother purchased the child's school clothes and also shoes for school that were not purchased by defendant father. Defendant mother has recently joined a church. She's been active in her church for the past year. She is not currently in a relationship. She does not have multiple people going in and out of her children's lives. Like defendant father has been in 2 relationships since the custody order and has lived with both girlfriends. The child has expressed his desire to live with plaintiff mother. Plaintiff mother has provided a permanent family and stable home for her youngest son and also for the minor in question here. She does have another child who is 6 years old, who she has provided stable living conditions for, and stable living conditions for when the minor child in question here is in her care and custody. Plaintiff mother has also worked hard to facilitate a relationship between the minor child and also the defendant father. She has never done anything to try and hurt that relationship between the two. But due to the instability of the defendant father and his inability to maintain stable housing, to be an active parent in the role of the minor child, especially at 12 years old, defendant father has not taken him to doctor's appointments or dentist appointments. Plaintiff mother has been the one to take the minor child to doctor's appointments and to sports physicals during the defendant father's parenting time. She was also the one to take and be present at the minor child's open house for school and purchase the necessary binders that he needed for school during defendant father's parenting time. For those reasons, we are requesting that the current custody order be reviewed by this court, and that plaintiff mother is awarded sole physical care and custody of the minor child. We are asking for joint legal custody so that the two parents can continue to co-parent and make decisions for the child together, but we are requesting sole physical care and custody of the minor child for plaintiff mother.
Okay, thank you. Ms. McNiff?
Your Honor, we believe that this motion was filed as a result of my client filing his motion to change domicile, which referee Bradfield did grant. So my client has had stable work, has had a stable home. He worked for Art Van for 9 years, and when Art Van went out of business, then it became a bit of a struggle for him to find a new job. He's been offered a new job in Little Rock, Arkansas, that potentially will be a much better fit for him than anything that he can find in Michigan. He anticipates that he can make upwards of $80,000 to $100,000 a year working for this furniture store in Little Rock. He has extended family in Little Rock, including a brother and other family members. So he believes that this move to Little Rock will be very beneficial both for himself and for the party's minor child. The fact that the allegation that my client has been homeless is absolutely untrue. He was in an argument with a past girlfriend, had some texts, those text messages would be hearsay. No time has he been homeless. He's lived on his girlfriend for the past 2 years. The minor child shares a bedroom with my client's girlfriend's child, who is the same age. The two boys share that bedroom. In the basement, they have like a playroom with a couch and game consoles and things like that, so that each child has the opportunity to have some space if they want, but they sleep upstairs in a bedroom, which is completely appropriate. My client's girlfriend does not use drugs. She does have depression and she takes medication for that depression, but she does not use illegal drugs. The allegations that she's using illegal drugs come from a woman who has had her children taken away for her use of illegal drugs and is simply not a credible witness whatsoever. My client has not been violent with this child. We believe that there was an allegation by a plaintiff this past winter of physical violence. CPS investigated. They did not substantiate. My client advises that he swatted the child on the bottom. The child is 12, and it simply was not a major issue whatsoever. He has left the child this summer with his mother and his grandmother at times while he's been going to Little Rock in order to secure housing for the family and in order to negotiate with his new employer as to the terms of that employment. However, now that he's been granted permission to move to Little Rock, the child will be residing with him completely and won't be staying with his mom or his grandma. The child failed one grade last year. My client is trying to teach him the consequences of his actions. He's been in constant contact with his teachers. He's been working with them. My client's mother and grandmother have also been working with the child. My client's grandmother is a retired teacher and has been tutoring the child. With regard to the tardies, if the child is 1 minute late, he gets a tardy so he can be dropped off at school in time. But if he dawdles and doesn't get to his classroom right on time, he does receive a tardy. However, my client has been on him in order to make sure that he is on school on time. My client has always provided clothing and school supplies for the child. He purchased a backpack and other school supplies for this year. There was a time when Ms. DeLong was purchasing school clothing for the children, but not permitting the child to bring the school clothes back to dad's house. So both parents had clothing at their own homes. This child absolutely wants for absolutely nothing. But the allegations that my client is unstable, that there are drugs in his home, are absolutely false. We don't believe there has been any change in circumstances other than the allowance of my client to move with the child to Little Rock, Arkansas. And we would ask that this motion be denied.
Okay, thank you. Well, what the court's going to do is obviously there's a lot of allegations, and obviously if the allegations are true and accurate, that it could serve as a basis for a change. I understand the answers. I'll say to you, Ms. Smith, is that based upon what Ms. McNiff has stated, if in fact the testimony comes in as she has stated, then court would find that there wouldn't be a basis for a change of custody, but I'm not going to, again, decide that matter on a motion when we haven't been presented evidence. So the court will grant you an evidentiary hearing on this matter, but I would state that if the proofs come in as Ms. McNiff has stated, that would in fact refute that, and the court would entertain at that time an assessment of a cost and attorney fees in this particular matter. So you can contact my office. We'll see when the attorneys are available, and we'll set it for an evidentiary hearing and proceed in that manner.
Thank you, Your Honor.
Okay.
Thanks, Your Honor.
Court will end this matter. Court will note the appearance of Ms. Reed on behalf of plaintiff, Ms. Podolsky on behalf of the intervener. In this particular matter, there are two motions: the intervener's second motion for custody and plaintiff's second motion for custody. Ms. Podolsky.
Thank you, Your Honor. As the court is aware, back in 2021, my client was allowed to intervene in the DP case. He is the plaintiff in the other matter, but these motions are relatively the same, involving siblings. There are current guardianships that penned before Your Honor that involve a court-structured plan for the mother of these children. Our motion outlines the services that she was to complete as part of that court-structured plan. While she has completed these services, we maintain that she hasn't necessarily achieved a benefit and has more or less gone through the motions of these services. Further, the department in those cases was ordered to provide counseling between the mother of these children and the guardian, my client in these matters, who is the grandfather of these children. To date, they have yet to do that. In those guardianship cases, the minor child, Corey, has stated a very specific preference about wanting to continue to live with his grandfather, the guardian. That is a home that both of these children have been in since birth. They have lived nowhere else. While at times the mother has lived in the home as well, she hasn't always, but those children have remained there. Their grandfather and guardian takes care of all of their educational needs, all of their health and wellness needs. He has them enrolled in various extracurricular activities. He ensures that they attend summer school programs so they stay caught up in the summer and aren't falling behind. Unfortunately, through the guardianship case and these services that were offered, the mother has not been able to build or reestablish that bond with the minor children. There's an allegation that my client is coaching the minor children, which is 100% false. This is a unique situation from other custody matters where these children know what's going on. They see an individual counselor. They see their mother's counselor. They talk to a CPS caseworker. They've talked to that caseworker's supervisor. They have a guardian ad litem who comes and visits them prior to the hearings. They are well aware of what is going on. They are well aware that their mother is seeking to have them come back and live in their home. So there is no coaching going on, Your Honor. They are just very involved in this process because of all of these services. But unfortunately, the services have not, again, panned out. We've gone through the motions, but we've not achieved that benefit. The mother's home often is lacking in food. My client is providing food. Specifically this summer, he had to provide food so she could provide lunches during the summer school program. The children come home with bug bites and flea bites. It's just unfortunate that the situation has not gotten better. So at this time, we feel that.
Hold on, Judge, they brought the wrong Jefferson. Do they have the other Jefferson? Is this? Said that they were getting him.
I wondered, the individual got up and left the room, so
Yeah,
I wondered. So I'll have to check with you. Are you Ken and Jefferson?
Yes.
Okay, thank you. Ms. Podolsky, let's try it again and see if we can get through it this time.
Okay, Your Honor, would you like me to start from the beginning or just continue where I left off?
No, you can give us the Cliff Notes.
Okay, thank you. As I was stating, we believe that through these court structured plans, it's just unfortunately that been a situation where the mother has gone through the motions of the services. There have been services that the department hasn't offered. They have provided reports for hearings, but they failed to provide the reports of the counselor for the minor children. And what we come up with is a situation where the children are in a home that they've been in since birth. They are well bonded to their grandfather. That is the plaintiff in the matter involving Charlie, the intervener in the matter involving Corey. He is their guardian. He provides them with all of the needs of life that, as it relates to school, their medical care, financial needs. And we are just in a situation where they do not have this bond with their parent that has not been rebuilt. It has not been restored through the various services. And we have children who are very involved in this process, who have expressed a very strong preference to everyone involved. And at this time, it's important to give these children permanence, to give them stability. They don't have that through the guardianship. So we are seeking to maintain the continuity that they have had their entire lives. We're asking the court to award custody to the guardian grandfather and continue the parenting time schedule for the mother that has been outlined in the guardianship cases. As it relates to Mr. Jefferson, he is the father of the minor child, Corey. He has not been involved in Corey's life. He has not been involved in the guardianship proceedings. Thank you.
Okay, thank you. Ms. Reed, what's your response?
Our position is, Your Honor, that Carly has participated in all services. She's benefited from all services. She has done everything according to the court-structured plan, including building a bond with her children. The children are actively involved in this process and are aware of this process. And to demonstrate that, Mr. Dillon elected to pull Corey out of school and have him present during the last guardianship hearing. So Corey knows exactly what's going on, and we believe that's highly inappropriate to do to this child in this very contested proceeding. As reflected in the CPS reports and the report by Sandra Burdick, it's CPS's position that Mr. Dillon's actively trying to thwart reunification between the children and my client, as well as refusing to participate in the counseling services. So there is active parental alienation going on. He is not willing to build that relationship or maintain that relationship between the kids and my client. My client does have a relationship with her children, and when they're away from Mr. Dillon, they look to her for love, guidance, and all her needs. She does have adequate food and clothing and all the necessities that these children need in her home. Parenting time goes extremely well. She had week on, week off during the summer. She had the children on alternating weekends during the school year without issue. There's no bug bites. There's nothing going on or no basis for these allegations other than Mr. Dillon does not want the guardianship to end, and he wants to keep these children from my client, which has been his basis since this started almost 2 years ago. So we're requesting that the custody be changed to sole legal, sole physical to my client, and that we would file petitions once that occurs in the guardianship cases to have those closed.
Okay, thank you. Mr. Jefferson, what's your response?
My response to all this is, since day one, when I came home from prison, there's been so much things that I've been going through as far as dealing with the mother. Like, I try to contact her and in almost respectful ways, can we talk about my kids? Can we do this? Can we do that? I was told so many times ago, I've never had the opportunity to meet the grandparents. So me wanting to be in my child's life, it's okay, yeah, I had to go through the courts to do it. So when I'm working, I pay the child support that I'm supposed to pay when I'm working. I just want to be a part of my son's life. That's it. I'm not concerned about nothing else. All I want is to be able to have some parenting time so we can build a bond. I never asked for none of this to happen. Everything as far as my son keep being away from me wasn't my choice. That is something the mother did. And I'm not sure what the grandparents have to do with her decision of keeping him away from me. But I've never, not one time, decided to say, hey, forget my child. He just had I just found out he played football. Well, I want to be a part of my son's life. I never asked not to be a part of his life. So whatever parenting time that I had to do to be able to be a part of my son's life, I would do that. But if you ask her, have I ever tried to communicate with her and talk to her about having times where I could bring him clothes, possibly give him a phone so I could talk to him? I will pay the bill every month. She no, you need to go through the courts to do this, do that. I'm okay, well, why do I have to do that if I'm able to talk to you? And if I could talk to the grandparents, then it shouldn't be a problem. But I don't know the grandparents. Never have I had the opportunity to, because when we first met, she told me that her parents was prejudiced. So with that being said, it kind of made me stay away from the situation because the way you already presented the situation to me. So I did go to prison. When I was in prison, we had a hearing. During the hearing, they asked, well, how did I feel about something? I'm like, well, the only thing I asked for when I was in my meeting then was to have some type of parenting time. Like, all I want to do is be able to spend time with my son. But they told me that because of the fact that he had his surgeries and she'd been with him, he'd been with her the whole time, that they gave her sole custody, which I never, you know what I'm saying? I never went against that. And I just been waiting for, like, I don't want to go through courts to be able to have to see my son because there's two adults that can talk about it and figure this out. But because of the fact that she'll never talk to me, if I message her, she'll block me. You know, I don't message her on no rah-rah, no extra stuff. All I ever want was to be able to talk to her at a decent tones and figure something out. That's all I ever wanted. But that never works. So now we're in a position where.
Thank you. Well, in this particular matter, the court is obviously well aware of this case because we had a guardianship review just last week in this particular matter. And so the court's aware of the facts. It is apparent that the child and children have been with the intervener grandfather for effectively been in his home since their birth. So what the court is going to do on a temporary basis, the court will grant to the intervener grandfather temporary custody in this particular matter. The court will maintain that status quo until we can have an evidentiary hearing. The court will also order that the parties would, plaintiff and defendant would pay support consistent with their incomes and the child support formula in this matter, and ask Ms. Podolsky that you would prepare that order and submit under a 7-day notice of entry.
Thank you. And is there parenting time for the mother to continue pursuant to the
correct
parenting time, the guardianship? Thank you.
Yes. Court will end this matter at 9:36 a.m. You're free to go. Have a good day.
I have a question.
Okay, go ahead.
How do I go about parenting time for myself?
You're going to have to file a petition and then notice that up to both of the parties, and then the court will hear it at that time.
Okay. Now, am I able to ask the mother a question?
No, you can file your petition and then we'll hear the petition.
So I can get that while I'm in here right now?
You can get that. Yeah, you can get it. You can file it anytime you want. There's no restriction on when you file that.
All right.
Okay, thank you. Have a good day. Ms. Thomas, on behalf of the plaintiff, Mr. Crow, on behalf of defendant, this matter is before the court on the plaintiff's motion for temporary custody, parenting time, and support. Ms. Thomas.
Thank you, Your Honor. Your Honor, Mr. Crow had called me while we were waiting, and we may have an agreement already, but just to reiterate, this is a case where Ms. Hinman moved out of state to Florida.
Well, why don't you give me, if you have an agreement? I don't need all the facts if we have an agreement.
No, well, that's what I was explaining. She lives out of state and the children live in Michigan with the children. And so my understanding from Mr. Crow is that she was looking for like regular phone contact and or FaceTime, that type of contact with them while she's in Florida. And then if she's in Michigan, that she was looking for parenting time while she's in Michigan, and that is fine with us. The only thing that I wasn't sure if we had an agreement on or not, because we were both cognizant that I had two this morning, we weren't sure exactly when they were going to be called, is that she was working when she was here, and they've acknowledged in their answer that she was making $600 a week. So we're asking that child support be set pursuant to the Michigan child support formula. But other than that, I think we do have a temporary agreement for him to have custody and parenting time as they can agree if she's in Michigan. And then child support is the only question in my mind.
Okay, Mr. Crow.
So, Your Honor, I did have the pleasure of speaking with my counterpart a few minutes ago while we were waiting for the court to call our matter. On a temporary basis, Your Honor, I believe that my client would be willing to consent that her parenting time will be as possible when she comes to Michigan, and that the gentleman will not unreasonably withhold consent from her having parenting time if she were to come up to the state. She's already having regular phone contact with the children. We'd like to keep it status quo as it relates to the phone communication. And on a temporary basis, this would not be objectionable, Your Honor. In our response, we were asking for the matter to be referred to the friend of the court, for the friend of the court to issue a recommendation. I understand that may not be the policy of the court, and if it's not the case, then that's fine. We would be asking for the order to be temporary, and my hope is that we'd be able to resolve sort of a standard out-of-state schedule in mediation or as part of the divorce. And as it relates to the child support issue, Judge, my client is not currently working. She was making $600 previously, but she's not working right now. So I would ask if the court would be willing to hold that in abeyance, perhaps until the mediation when we can resolve all the issues. Thank you, Judge.
Okay, thank you. Well, what I'm going to do is it appears that we have an agreement as to temporary custody, and that would remain with the plaintiff, subject to her rights of parenting time if she obviously is in Michigan. Again, court would simply order that would be reasonable at times that the parties can mutually agree. If they can't agree, come back into court and we'll set something in place, but hopefully we don't have to do that. I'm not going to hold up the support in abeyance. What I would do is, if she's not working currently, the court would impute $15 per hour to her for purposes of setting support. There's not been any allegations that she is not able to acquire that amount of income for purposes of the support obligation. So that will be the order of the court, and I'll ask Ms. Thomas that you would prepare a appropriate temporary order and submit that under 7-day order.
Okay, thank you, Your Honor.
Thank you, Judge.
Thank you. Court will end this matter at 9:42. Court will note the appearance of Ms. Thomas on behalf of the plaintiff. What?
Judge, if you can wait just a second, they're swapping people. Come on in. They're swapping people for me. Come on in. Okay, you're good. You're sitting right there. Okay, we're good now. Thank you.
Okay, go ahead, Ms. Thomas.
Okay, so in this particular case, this is our motion for temporary custody, parenting time, child support, and exclusive use of the home. The parties do have one minor child, a son. He's 6 years old. Defendant was personally served in at the party's camper, which he has parked in his brother's driveway in Bellevue, and he was served on September 12th. However, since then, we've not received an answer in any way other than he did indicate to Ms. Boyd that apparently she didn't realize where he lived. He really lived at the marital home. But other than that, there's not been any response, nothing with regard to that. So what we're asking, as set forth in the plaintiff's motion, and for those reasons that are set forth therein, that she has the primary care, because she has been the primary care provider for Braxton since birth, that she desires to remain the status quo, and that she continue to have the minor child remain in the home with her, having exclusive use, and also her having temporary custody of the minor child, with defendant having reasonable parenting time. Based upon defendant's continued excessive use of alcohol, she would request the court to impose restrictions regarding defendant's ability to drink during and prior to said parenting time. She's also requesting that child support be set pursuant to the Michigan child support formula as set forth in her motion.
Thank you. Mr. Boyd, what's your response?
Can I I've got a lawyer's meeting tomorrow morning. Can I postpone this for a week? I'm meeting with a lawyer tomorrow morning at 9:00 a.m.
Okay, the court will grant your request for an adjournment. We'll adjourn the matter 1 week and have the matter back next week at 9:00.
Okay.
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 Yes,
No need to re-notice.
No, you don't need to re-notice it. We'll just take the matter back up next week.
Okay, thank you.
Christy, did we enter an order on this?
I'm not sure. I know they emailed an order to me and I told them that they would have to contact the clerk's office in order to get that order entered, and I didn't hear anything back. So
okay,
I'm not sure.
Court will note the appearance of Mr. Schaefer on behalf of plaintiff, Ms. Elaine on behalf of defendant. This matter is before the court on the plaintiff's objection to the defendant's order. Mr. Schaefer.
Please the court, Your Honor. There are a number of orders out. I think all of them got agreed to except for this one, and that the only objection that was filed was in relation to two words under paragraph 2. That reads, the provision does not apply to periods of 1 hour or less and defendant's wordage is before school. We're objecting before school. That's the only objection that we have. I think by excluding that, it encompasses that which was discussed, argued, and ruled upon by Your Honor, that it made no sense to have somebody drive a half hour one way, that there was an hour time period, no matter if it was in the morning, before school, or in the afternoon. So I think it's consistent with the ruling of the court to exclude the two words before school.
Okay. Ms. Elaine, I know we went through this before. That was my understanding, is we were going to say that, if it's an hour or less, I don't believe that we talked about, including the language before school.
We did, Your Honor. In fact, this was the exact objection Mr. Schaefer made at the September 11th hearing and the June 26th hearing. This is like Groundhog Day. This court rejected that language at the last hearing, which was, both hearings, it rejected that language. So this is the third time we've been before this court with this particular language at issue. I've got a transcript from the June 26th hearing to read to you, and I've got the YouTube section of your ruling to play for you from the September 11th hearing. This court ordered that because there is only a transportation weirdness that occurs in the morning, it would not interpret the parenting time provision to apply to periods of time where Alexis could only produce the children for an hour or less. However, in the afternoon, that transportation problem does not exist. Mr. Schaefer just doesn't like the ruling of this court. Alexis Tabaka does not like the ruling of this court because she is engaged in a battle to thwart parenting time that Dr. Tabaka is entitled to have. It is egregious to me that we're here on this again. And what the court ordered on June 26th is the following, and this occurs on page 17 of the transcript. Court says, if she's working at the office and the kids need to be picked up from school, taken to piano, whatever it might be, he has the right to do that until such time as she gets home from the office. Mr. Schaefer said, so if she comes home from the office to pick up the kids, then she would be able to pick up the kids. Court said, yes, correct. The court said, I don't want it to apply. Well, grandmother, aunt, uncle, neighbor, or that type of thing who would be picking up the kids. It should be with the parents. And if it can't be with the plaintiff, then they should be with the defendant. This is in the midst of arguing about this time parameter and where that should apply. And the court was saying that it has to apply in the morning because of the transportation from Battle Creek to Marshall. But because the kids are in Marshall schools and the father lives right there, there is no time limit on the afternoon, because what that would mean is if she weren't available for a half hour in the afternoon, other people, grandmothers, aunts, uncles, neighbors, or most recently, Alexis's tenant will pick up the children after school for 15 minutes or 30 minutes and divest Dr. Tabaka of that parenting time.
Okay, clarify for me if you can. I don't understand. I guess I'm missing something. Is that
okay?
The hour, Mr. Schaefer says, should not include where it says just before school. And I'd already ruled that on the September 11th date that hour provision wouldn't pertain to after school.
Right. But he wants it to pertain to after school. Mr. Schaefer is arguing that if she is not available from the time they get out of school for an hour, then Dr. Tabaka can't go pick them up, which is directly contrary to the whole point of what this court ruled. Okay. Well, that was my understanding of the way I ruled on September 11th. And we addressed that specifically. So Mr. Schaefer's order was rejected. Sorry, Your Honor. The hour provision would not pertain to after school. Correct. So, right. I guess from that standpoint, Mr. Schaefer, I guess I would deny your objection because I'd already ruled on that on the 11th. So,
well, there's a lot of rulings.
I know. That's why I was a little bit confused.
Yeah, and the problem is that we're dealing with a 2016 that the words are being parsed and being applied inappropriately. So I think what I had suggested was consistent with your overall ruling. We'll live with whatever Your Honor believes that he ruled, but I think
I'll stay with what Ms. Elaine had said, that the hour would only be before the school, and that any time after that, as the court ruled on September 11th, it would be that he has a right and he wouldn't be limited by that hour provision. Your Honor, I would ask for attorney fees. This was explicitly clear on September 11th, and Mr. Schaefer's language that he submitted for this purpose today
was the same as the one the court rejected on September 11th. I emailed him immediately after he filed this objection, which is the third time we've been to court on this particular order, and pointed him to the place in the YouTube where you made your ruling. He just didn't respond to that email, and we're here. I would ask that he pay my attorney fees for an hour of time for $400.
Okay, well, go ahead, Mr. Schaefer.
Your Honor, again, it wasn't clear. Your Honor is struggling through it. I struggled through it. I went and reviewed it, and I am not clear that it was before school. And it certainly is a legitimate matter to bring back in front of the court. I don't think the attorney fee is valid at all, and I'd object to that.
Okay. Well, the court's not going to grant the attorney fees at this point. I can understand how there may be some confusion, but obviously it does appear that, I addressed this matter back on September 11th, but I'm not going to award the attorney fees at this time, but if we continue to labor at this issue, that would be appropriate. So, Ms. Elaine, do we have your order?
Yes, Your Honor, I did email it to Ms. Woodward this morning. I would ask, please, if we could prevail on you to sign that from the bench so we don't have a fourth objection.
No, that's fine. I'll get it filed. I'll get it signed today.
Thank you. Okay. Thank you, Your Honor. I appreciate it.
Court will end this matter at 9:54 a.m. You're free to go. Have a good day. Court will note the appearance of Mr. Vollmerine on behalf of the plaintiff, defendants appearing in pro per. This matter is before the court on the defendant's objection to the referee recommended order. Ms. Wilson, you can proceed.
My objection obviously has to do with the fact that the evidence that I submitted to the court was not properly scanned in. He had referee Croto had no paperwork that I had given to the clerk's office in any logical order. I have no idea what did actually end up on his desk and what ended up not being on his desk to be able to correct the situation. Nor am I versed in Zoom to be able to screen share. I told him, I was like, okay, next time we get together for a hearing date, I will obviously have perfected those skills in order to make sure that he has the proper documentation. And I'm able to present that to both the plaintiff and him during proceedings.
Ma'am, you understand that in the notices and the whole thing on the Zoom, it tells you that you're responsible for those documents, and you're responsible for making sure that you are able to screen share those and present those to the court. That wasn't ever on my screen. That warning was never on my screen. Okay, well, it's your responsibility as a party. It's no different than Mr. Vollmerine. If he wanted to present something and he couldn't do it at the hearing, it's nobody's responsibility but his. So in your case, it's your responsibility to make sure that those are able to be shared and presented to the court.
Okay. Yeah, that was not on the screen that I saw at all. And in addition to that, like, this documentation was not properly scanned in by the clerk's office anyway. So he had no way of even knowing what I was presenting. Either way.
Again, it's your responsibility. So.
Okay, so when I hand in the paperwork to the court for evidence, for submission of evidence, and he does not receive that documentation after it's out of my hands, there's nothing I can do about that particular line of evidence submission.
Well, there's a lot of things you can do. You can, as you already acknowledged, you can do the screen share. You can present it. I don't know if this hearing was in person or not. I assume it wasn't.
It was via Zoom. Sorry.
Okay. So, but it's your responsibility to make sure that those get submitted at the time of the hearing. Because what will happen when you submit documents to the clerk's office, it's not unusual. Parties submit voluminous documents, and yet they may use a fraction of those documents at the hearing. Just they determine that they're not useful or that they don't want to admit them, etc. And so it's your responsibility to make sure that that gets done properly. So go ahead.
Also, there was the referee in-camera interview. Do we have access to that interview?
An in-camera interview is privileged and confidential. We do not have It is not shared by anyone. It's not to leave that particular room. So the parties, the attorneys, even myself will never find out what occurred at that interview.
And the next issue was the fact that referee Croto had stated in previous proceedings that he disliked breaking up testimonies from witnesses. So I did not subpoena two of the witnesses that I was going to have to recall due to that fact that he had stated that displeasure in that. In the last day, it was forced closing. The closing statements was demanded, even though the paperwork was not correct. I told him that I would learn how to submit the paperwork via Zoom screen and everything, but there was no chance at all for me to counter an expert witness. I have no idea what he admitted to, not ever calling me back, never contacting me, and there was no opportunity for me to rebut his testimony as an expert witness.
You called, didn't you call a CPS worker and had that person testify?
I had the one person, yes.
Okay, so you know how to get somebody to testify then, correct?
Yeah, and I was not afforded the opportunity to get the evidence I needed for an expert against an expert witness. He testified.
There was a hearing on May 12th and then again on August 3rd. You could have subpoenaed an expert for either of those particular hearings.
And I would have if I knew what the plaintiff's expert witness was going to testify about.
You can't just say, well, geez, they've presented their witnesses and now I think I need an expert. That's not how trials work, ma'am. You have to have your witnesses present and available for testimony.
And I understand that. However, the simple fact is the expert witness that the plaintiff called would not contact me back. And I have no idea what he's going to witness against. So therefore I have no recourse as to this is the expert witness that I would call to counter his testimony.
The other party's experts are not required to contact you back. They're not required to have any communication with you. They're the other party's witnesses. They're the other party's expert, and they testify at trial. And you have to prepare your case, just as Mr. Vollmering had to prepare his case, and present the case as best you can. You can't, if you wanted to have, let's say, information, or you wanted to have forewarning as to what the expert was going to testify, you could have had that expert take a deposition, and you could have went through all of that testimony at that time in preparation for your hearing.
With the witness who does not get back to anyone, including the CPS witness.
You subpoena the person and they are required to show up for their deposition. Or if you subpoena them, they're required to show up for the hearing. So obviously you have a disadvantage a little bit because you're representing yourself, but that's the responsibility that you take on when you represent yourself and don't have an attorney. So that's unfortunate. Anything else?
Yeah, the wording of that the referee put for the attorney fee section, last page, third paragraph, it implies that I'm to pay all attorney fees in that the show cause hearing, which is what the entire custody case is the show cause. He didn't specify it was the show cause for contempt of court or if it was the show cause for the entire situation.
Okay. Mr. Vollmering, what's your response?
She did not put that in her objection, Your Honor.
Okay. Anything else, Mr. Vollmering?
I guess I'll just add to that. There were two competing show causes. I asked for attorney's fees on both of them as a result of frivolous pleadings filed by the defendant here. So my interpretation was that it applied to both of those show causes.
Okay. Anything else?
No, Your Honor.
Okay.
Well, is this in response to all of what she was saying? Or
in response to everything.
Okay, I guess as far as the other items go, I think the court pretty well hit on it, and I also will primarily rely on my pleadings there, but it was the defendant's responsibility to subpoena her witnesses and to prepare her documents and exhibits for trial. She has shown an ability to do so in the past and just chose to not do so this time. And so again, I'd just like to reiterate, I'd like attorney's fees for having to appear for this motion as well.
Okay, thank you. Anything else, Ms. Wilson?
Apparently not.
Okay. Well, in this case, the court did have opportunity to review the ruling of the referee. He did make a very thorough factual and legal decision in this particular matter. He did address and found issues of credibility to be substantial in this matter, as well as finding that the established custodial environment was with the plaintiff in this case. And as a result, the court, after I reviewed that and thoroughly reviewed it, the court cannot determine that the referee made either a factual or legal error in this matter. So the court is going to deny the objection in this matter. And that will conclude the case. And
I do have something that's slightly off topic that has to do with paperwork and filing in your guys' office, if you wanted to hear about it.
well, if it doesn't go to the objection, I don't care to hear about it because it's not before the court today.
So the fact I have somebody else's information from their court date and their rulings and their custody case in my envelope sent to my home isn't concerning.
Well, that obviously it's always of a concern, but it doesn't affect these particular proceedings. And what you need to do is you'll need to file a complaint with the front of the court because they would have been the ones that sent that out to you. So you can file a complaint with them.
Okay.
Court will end this matter at 10:46 a.m. You're free to go. Have a good day.
Your Honor, real quick, on my attorney's fees, was that denied?
I'm denying that at this point. Yeah. Court will
Thank
note
you.
the appearance of Ms. Reed on behalf of plaintiff, Mr. Magnuson on behalf of the front of the court. This matter is before the court on the defendant's objection to the referee recommendation. Mr. Northrup.
Yes.
Okay, present your case.
I have two pay stubs here in front of me. Roughly $16 an hour at 76 hours. And then I got another pay stub here for $16 an hour at 78 hours.
Okay.
So roughly the gross is 2,000. I'm rounding high here, about 2,400.
Okay, and so that's the basis of your objection.
Yes.
Did you see Mr. Magnuson's response to your objection?
No, I haven't.
Okay. Well, Mr. Magnuson has stated in his response that the matter is going to be consolidated with a divorce case that is pending. And as a result, the support could be recalculated in that divorce action. You understand that?
Yeah. Yep.
Okay. Mr. Magnuson, that's the substance of your response?
Well, I concur with that response, Your Honor. It was actually Attorney Reed, I believe, that filed that response,
okay.
But
okay.
I do concur with it. And also, frankly, there's been a lack of specificity from the defendant's part until this time as to his income. But I do believe with the fact that this matter is being incorporated in a divorce, these issues can be handled. And I believe that the income that the referee used was approximately $18 an hour, and Mr. Northrup is claiming $16 an hour. So it's not inordinately out of line, and it can be adjusted through the divorce, I believe.
Okay. Thank you. Ms. Reed, I referenced your response as Mr. Magnuson's, but anything else you'd like to add?
That is correct, Your Honor. That's our position, but Mr. Northrup has to participate. I have not received his domestic relations verified financial information form. I haven't received any sort of documents from him other than the initial complaint for divorce. We do have mediation coming up in October, but he needs to supply me with those documents if he wants child support recalculated.
Okay. Do you hear that, Mr. Northrup? You have to do a certified financial verified financial statement and provide documentation. That was my question when I saw your objection, is no place in the objection to state what your income was. So the court would simply have to guess. And I don't know if that's what the referee had to do as well. So what the court's going to do is I'm going to deny your objection. You can, again, file the paperwork in the divorce action. We can get it recalculated at that time, and that will take care of any potential mistake or error that you claim might have existed. Okay?
Okay.
Okay. Thank you. The court will end this matter at 10:51 a.m. You're free to Court go. will note that Have a this good matter is day. before the court on the
Thank you, Your
defendant's
Honor.
motion to set aside referee recommendation in this matter. Mr. Ochin, you can proceed with your motion.
My motion is the amount indicated as my monthly income is incorrect because my salary is $859 a week if I worked 40 hours a week. But I've been working like 60, 55 hours averagely a week to pay up some debt.
Okay. Well, sir, what happens, the court did review the file, and I reviewed all of the documentation. And what it showed is that your paycheck or whatever you submitted showed income as of September 1, 2023 in the amount of $46,182.05. If we divide that by 35 weeks, that gives you an income of $1,319.48 multiplied by 4.3 weeks. That gives you a monthly income of $5,673.76. That's approximately $700 more than what you claim that you make on a monthly basis. So the referee didn't make an error. What happens is the referee took less income in deciding the support amount than what you actually make.
Okay, sir. Cause I've been, I just divorced. Like I got divorced like a couple years ago, and I was left with a lot of debt. That's why I've been working like over 40 hours a week, averagely. Like it is indicated on the pay stub that I submitted, and
Right.
also.
But what they do is they figure support based upon your income. It doesn't matter that you're working extra because you want to buy a new car, you want to go on vacation, or you have to pay bills. They do it based upon your income. And in this case, the referee did it and actually gave you a substantial benefit of calculating on $700 less per month than you actually make.
Okay.
So if in fact your income changes in the future because you've paid things off, you always have a right to have it modified at that later date, but based upon what the referee calculated it, based upon the income you supplied, the support amount is more than a fair amount to you.
Okay, Your Honor, if I worked 40 hours a week and paid the federal taxes, I won't be able even to make it. Like right now, you can see on my pay stub that I don't even pay my federal taxes.
All that may be fine and good, but they do your support based upon your gross income calculated on a weekly and monthly basis. And all I'm saying to you is you're making more than what the referee even calculated on. So the referee didn't make an error. I understand that you don't want to pay that, but it's not an error on the part of the referee. He's figured support correctly based upon the child support formula for the state of Michigan.
Okay.
Okay. Ms. Smith, is there anything else you would like to add?
Nope.
Okay. So the court will deny the motion in this matter, as the court does believe that it's more than fair based upon the income provided by the defendant or the plaintiff in this particular matter. So That will be the order of the court. The court will end this matter at 10:57 a.m. You're free to go. Have a good day.
59 a.m.
Thank you.
Court will note that this matter is before the court on the defendant's motion to set aside referee recommendation. Based upon your motion, it appears the basis of this is that you're stating that there is no childcare cost.
Yeah.
Is that correct?
Yeah.
Okay. And you're saying that hasn't been incurred. You'll have to enlighten me. I don't know what happened at the referee hearing or anything of that nature. Was there testimony about the
I don't know if we had told them that there was no more childcare, that he wasn't in childcare no more. I don't know what happened as far as if it got like noted or something, but he hasn't been in childcare since January or February.
How old is the child?
4.
Okay. And why is there no childcare at this point?
We had pulled him because of the fact that it was getting too expensive.
Okay. Has the plaintiff at any point acknowledged that there's no childcare?
Yes.
And when?
She's sitting right next to me, so she can probably tell you better than I can.
Okay. Well, good. I was hoping that she would appear and I could ask her.
Hi.
Hello. How are you?
Good.
Ms. Snyder, is the fact that there is no childcare, is that correct?
That is correct.
Okay.
He had some difficulties there, and we felt that it was a better environment for him to be with us than there.
Okay. Okay. Thank you.
Okay.
Well, what I'm going to do, Adriana, is obviously it's your motion. I'm going to have you're going to have to resubmit the orders under 7 days. So you'll have to resubmit it within 7 days, which would take out the childcare calculation and then only have the other amounts included. Okay.
Okay.
So you just resubmit the uniform child support order without childcare, and then the court can enter that particular amount.
Okay. So how do I go about getting the papers for that?
Okay. What you can do is go to michiganlegalhelp.org.
Okay.
And it's an online service, and they have all of the forms there. And you'll go to, again, the uniform child support order, and then you just put in the numbers that they had, but take out the childcare cost, and then that should give the correct amount that you would have to pay.
Okay.
And then you can submit that under what they call a 7-day notice of entry. If you submit it within 7 days of today's date, then the court can enter it. If it's after that, you're going to have to notice it up for entry.
Okay.
Okay.
Yep.
Go to michiganlegalhelp.org, and that will give you all the paperwork that you need to submit that order.
Okay. I have it wrote down.
Okay. Great.
All right.
Okay. Thank you. Court
Thank you.
Matter at 11:03 a.m. You're free to go. Have a good day. This matter is before the court on the plaintiff's motion for extension of time to file a revocation of paternity action and to determine the child is born out of wedlock. Ms. Scott, has any paternity testing occurred to date?
No, it has not. I've been trying to have Jalen, because he lives in the state of Virginia, and I was letting him know that he needs to go to a court-approved DNA center, so that way we can get some testing started, because I have Aviana with me here in Michigan.
Okay. Has Mr. Scott,
And I was going to go
has
to a
Mr.
DNA center
Watson,
here.
has Mr. Watson had any DNA testing?
I didn't hear you were going in and out.
Okay. Well, okay. Has Mr. Watson had any DNA tests conducted?
No, I've been trying to tell him to get his done too. At first he agreed to do it, but once he knew child support was going into effect, he kind of
Okay. Well, what you can do is
ducking and dodging.
What you can do is you can do an order for paternity testing, and we'll put it in the order that both Mr. Scott and Mr. Watson would submit to DNA testing. And that way, once we get testing from one of them, we'll be able to determine whether the child should be excluded. And then we could have what we do as a Wednesday afternoon hearing where we take testimony in this matter. We don't do that on Mondays just because we have too many hearings. But
Okay.
you'll have to do an order for paternity testing, and you can get that order the same place that you got all the paperwork to file both of these motions, okay?
Judge, I believe she's filed, let's see, she filed an order regarding request to determine child born out of wedlock. So, no order for DNA testing. Let's see what this order is. She filed an order regarding motion for extension of time to file action for revocation of paternity.
Okay. Well, that'll be the subject. I know you state in there that the defendant prevented you from filing because you wouldn't take a paternity test. That doesn't keep you from filing in this matter, but we'll address that at the evidentiary hearing in this matter. So at this point, you're going to need to do the order for paternity testing and submit that to the court. Okay?
Okay. And then do I just turn that into where I turned all my other paperwork in?
Yes, at the clerk's office.
And so would I just get an order for paternity testing and get it served to both Jalen and Demetrius? And that way, whatever one takes one first, it kind of.
What happens, the court will enter an order ordering both, and once we get one of them to take it, then we should be able to have our hearing. The court won't schedule a hearing until after we have DNA testing conducted. So when that testing gets conducted, then you're going to have to contact my office and say that you do have the report at that point, and then we'll schedule a Wednesday afternoon hearing.
Okay.
Okay? But submit
Thank
the
you.
order. Submit the order because nothing will happen until you have that order submitted.
Yep, I'll get that done today.
Okay,
PM
thank you.
Attorney Jesse Fernandez for Attorney Sharp for plaintiff.
Okay. Mr. Fernandez, I'll say good afternoon to everyone. Mr. Fernandez, what are the issues in this particular case?
I was asked to cover a couple minutes ago, but I believe everything is contested at this point, but the parties are going to mediation. And we're still working on discovery. We would need another 60 days to exchange to make sure that we know all of the relevant issues.
Okay. I think we have a little bit of time, so.
Okay.
What I'll do is I'll give you discovery through the end of December. So I'll put January 1 as the cutoff date.
Perfect.
And when are you going to mediation?
Let me see if it's on the calendar yet. Yeah, we don't have a date yet, but we have selected a mediator, so we'll reach out.
And who is that?
Matt Balke.
Did you say Matt or Mac?
Matt, M-A-T-T, and then B-A-L-F-E.
I'm just not familiar with him, so.
Yeah, I think he's relatively new, but his rate is much more reasonable than a lot of the mediators we work with.
Okay. Ms. Frew, you've heard Mr. Fernandez say what's happening. Is that your understanding as well?
I had no idea they were doing mediation, so but I knew they wanted to eventually, so I guess it's no surprise to me.
Okay. Well, the court always orders the matter to mediation anyway, so it's not like they're trying to pull anything on you. It's, It would be set for that. I'll put that, I'll just put the mediation will occur in December, but you can get it in before then if it works. If December would be a deadline then.
Okay.
If you're not able to come to an agreement on other dates.
Perfect.
Court would set January 8th, 2024 as the settlement conference date. It's 1:30 p.m. Parties are required to be present. It will be by Zoom. And we will, at that point, if we don't have resolution, the matter will be set for trial. So anything else, Mr. Fernandez?
No, Your Honor, thank you.
Ms. Frew, anything else?
No, Your Honor, thank you.
Okay, thank you. The court won this
I'm sorry.
matter. One, what?
I'm just sorry. Could you repeat that time on the January 8th settlement conference? I'm trying to write these.
1:30.
1:30. Okay, thank you very much.
Court won this matter at 1:38 p.m. You're free to go. Have a good day.
Thank you.
Thank you.